Madam Deputy Registrar, can you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, appellate jurisdiction on appeal from the Court of Appeal of Belize, judgment delivery in BZCV number 3 of 2023 between Wilfred P. Elrington and Progresso Heights Ltd. The members of the delivery panel are Mr. Justice Saunders, President and Presiding Judge.
Good day, Counsel.
Mr. Justice Anderson.
I am not sure that Justice Anderson is with us, nor is Justice Jamadar, who unavoidably is out of the state.
Thank you, President. Madam Justice Rajnath-Lee.
Good afternoon and good morning to everyone.
And Mr. Justice Burgess.
Good afternoon and good morning to everyone.
May we have the appearances, please? Thank you.
May the President and the Honorable Justices of the Caribbean Court of Justice, Wilfred P. Elrington and Paulette Elrington Cyril, appear for the appellant Wilfred P. Elrington.
Yes, good day again, Counsel.
May it please the court, Mr. President and the Honorable Justices of the Caribbean Court of Justice, Priscilla Banner, appearing for the respondent, Progresso Heights Ltd.
Thank you, and good afternoon again, Ms. Banner. The main judgment in this matter was authored by Madam Justice Rajnath-Lee, and I will ask her to read a summary of the judgment.
Yes, thank you, Mr. President. This summary is not intended to be a substitute for the reasons of the Caribbean Court of Justice or to be used in any later consideration of the court's reasons. This appeal was from the Court of Appeal of Belize. The parties were Mr. Wilfred P. Elrington, Senior Counsel, the appellant, or Mr. Elrington, as we refer to him throughout the summary and the judgment, and Progresso Heights Ltd, the respondent or the company, as they are referred to throughout the summary and the judgment. The respondent is a company incorporated in Belize. The appellant is a 20% shareholder in the company. The directors of the company are father, Mr. Lawrence Schneider, referred to as Mr. L. Schneider, and son, Mr. Adam Schneider. They hold the remaining 80% of the company's shares. The appellant lodged several cautions against lands owned by the company. The company commenced claims in the Supreme Court against the appellant and the Registrar of Lands to compel the removal of the cautions. The claims were consolidated and the trial judge ruled in favor of the company. The trial judge found that the cautions were unlawfully lodged by Mr. Elrington and unlawfully accepted by the Registrar of Lands in breach of her statutory duty. The trial judge ordered that the cautions be removed and that no further cautions were to be accepted without the permission of the court. Special and general damages, interests, and costs were awarded to the company. Mr. Elrington appealed to the Court of Appeal, and that court noted that only one of the 7 grounds of appeal challenged the primary finding of the trial judge. The Court of Appeal agreed with the trial judge that Mr. Elrington was not entitled to lodge cautions against the company's lands, since he did not have an unregistrable interest in those lands as required by the Registered Lands Act. As to the other 6 grounds of appeal, which all concerned whether the proceedings were commenced by the company with the requisite authority, the Court of Appeal disposed of those grounds summarily, as none of them had been raised by Mr. Elrington in his defense. The question of whether the claim was legitimately brought by the company did not arise on the pleadings and therefore was not an issue. The appeal was dismissed and the order of the trial judge affirmed. Mr. Elrington appealed to the Caribbean Court of Justice. The court, In his original notice of appeal, Mr. Elrington filed several grounds of appeal against the decision of the trial judge. These grounds included that the trial judge's decision was against the weight of evidence and that the trial judge erred in law in finding against the appellant on whether the company had passed any resolutions authorizing the directors or any of them to sell or otherwise dispose of any land belonging to the company. The grounds also included that the trial judge erred in being satisfied that Mr. L. Schneider had both actual and ostensible authority as director and agent of the company to sell the company's lands or to testify on behalf of the company. It was also claimed that the company was not properly a party to these proceedings. The appellant also filed grounds of appeal against the decision of the Court of Appeal. On the date of the hearing of the appeal to this court, the appellant filed an application to amend his notice of appeal to substitute the words trial judge or high court with the words court of appeal. This court dealt with the application to amend in its substantive judgment. In the lead judgment of the court, Justice Rajatli identified two issues which arose for determination. The first was whether leave should be granted to the appellant to amend his notice of appeal. The court examined the ambit and objectives of the Caribbean Court of Justice Appellate Jurisdiction Rules 2021 in relation to applications to amend documents which had been filed in the court. The court was not minded to grant the application. It must have been clear to the appellant that he could not appeal the findings of the trial judge before this court. The court noted that it is the decision of the Court of Appeal which is subject to the scrutiny of this court. Notwithstanding the refusal of the application to amend, the court determined the merits of the appeal on the assumption that the appellant was challenging the decision of the Court of Appeal. The second issue identified by Justice Rajatli was whether the Court of Appeal was correct when it held that the appellant could not succeed on his appeal due to his failure to plead that the proceedings were commenced by the company without the requisite authority. The court emphasized the importance and function of pleadings to give fair notice of the case, which has to be met, so that the opposing party may direct their evidence to the issues disclosed by those pleading. The court held that there was no reason to interfere with the view expressed by the Court of Appeal that the question whether the claim was legitimately brought by the company did not arise on the pleadings and was therefore not an issue. It has not been disputed that that issue was never raised in the appellant's defense. In addition, the appellant did not seek to strike out the claim brought by the company. Further, the appellant did not seek to appeal the trial judge's ruling, granting the company's application to permit Mr. L. Schneider's evidence to be given at the trial by video link, even though the trial judge had accepted by that ruling that Mr. L. Schneider had the requisite authority to make that witness statement. The court also observed that the appellant made no application to amend his defense to allege that the company's claim had been brought without the requisite authority, despite the strong objections by counsel for the company during the cross-examination of Mr. L. Schneider on that issue. Mr. Justice Anderson authored an opinion which highlighted that the appellant's appeal was brought as of right, but may be struck out if this court considered it an abuse of process, or if the issues pleaded were not properly before the court. He noted that abuse of process was a very high bar and considered that there must be an element of, or akin to, a showing of bad faith. The judge was not prepared to consider that the appeal had reached that bar. The judge then considered whether there were other grounds on which it could be argued that the appeal was not properly before the court. Emphasizing the importance of pleadings as providing the guardrails of litigation, Mr. Justice Anderson found that the application to amend the pleadings was not simply to amend clerical errors, but went to the structure and substance of the case and had taken the respondent by surprise. As such, Mr. Justice Anderson argued that the application to amend should be refused. Mr. Justice Anderson also found that there should not be deviation from pleadings that place the other side at a disadvantage. And in this instance, he found that 6 of the 9 issues on appeal to the court could not be considered as they had not been properly raised in the pleadings in the High Court. Where issues were not anticipated arise and which are properly incorporated into the case of one or other of the parties, the attorney wanting such incorporation or to make an oral or written application for an amendment of the pleadings. The simple solution would have been for Mr. Elrington to have made an application to amend the pleadings at the appropriate time before the trial judge. This he had failed to do. As this court has no jurisdiction to hear appeals from decisions of trial judges, the appellant's first 6 grounds of appeal were not properly before this court. Mr. Justice Anderson found that the remaining 3 grounds of appeal were against interlocutory decisions of the trial judge. He reiterated that there is no right of appeal of interlocutory decisions. This appeal could not be sustained as the remaining 3 issues were in essence an appeal from certain interlocutory proceedings before the trial judge for which leave had not been sought or granted. Accordingly, the appeal to the CCJ was not properly before the court. Following these judgments, the appeal was dismissed, the orders of the Court of Appeal were affirmed, and it was ordered that the appellant pay to the respondent costs of this appeal as agreed to by the parties. Thank you, President.
Yes, thank you, Madam Justice Rajnath-Lee. Ms. Banner, we did note the amendments in relation to the correction of the spelling of your name. And so we will ensure that when the judgment is placed on the website and formal copies are sent to you, that the correct spelling is there. Is there anything else from council?
Much obliged, Your Honor, Mr.
Yes.
President.
Much
Thank you very
obliged.
much.
Much
Yes,
obliged.
thank you very much, Mr. Elrington. That brings us to the end of these proceedings, and I would ask the Deputy Registrar please to close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath-Lee. Thank you, Mr. Justice Burgess. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.
Thank you.